Marty Shumway. Thank you very much. It's nice to see some of those numbers ticking up. Next to the stage is going to be Mr. James Elliott. Mr. Elliott will be providing an update on US EPA's efforts to regulate emissions from the oil and natural gas sector. Mr. Elliott's an attorney with Spillman, Thomas, and Battle, and he's located in their Greater Harrisburg, Pennsylvania office. His primary areas of law are civil and criminal environmental law. He has experience with appellate and trial litigation work. He does agency rulemaking work, and his special area of expertise emphasis is the Clean Air Act. For the past 5 years, he's represented the IPAA and numerous other state and federal oil and gas trade associations challenging EPA's new Source Performance Standards, NSPS, for VOCs and methane. Mr. Elliott.
Thank you very much for the opportunity to be here. I wanted to thank Sean for asking me a couple months ago, this was before the election, so at that particular time, I really had no idea what I'd be able to report on, but things have changed. It's been a very interesting couple of months since the election. Also want to say I've enjoyed working with the folks from OOGA, had the pleasure of working with Penny and Tom while he was the director. Since 2012, when we basically got involved in the Quad O litigation. Going to kind of quickly catch you up. I assume most of you have a pretty good knowledge of how we got to where we are, but this really goes back to 2011, 2012, when EPA first promulgated the Quad O VOC standards for new sources and modified sources. At that time, IPAA and a handful of state associations got organized. OOGA was included in that, and we filed a petition for judicial review in the D.C. Circuit Court of Appeals. We also filed an administrative petition for reconsideration with EPA. At that time, in 2012, we received a lot of positive feedback from the agency that they were going to be willing to work with the trade associations and the industry to make revisions to Quad O in such a way that while we actually had a lawsuit filed, we were working through administrative petitions rulemaking. So through 2013 and 2014, we worked to tweak the Quad O, try and improve it, address the most egregious issues, and we continued to basically stay or put in advance the actual litigation. 2014, 2015, things changed dramatically in terms of it was very clear that EPA was moving towards the direct regulation of methane, that they were going to revise the Quad O regulations. They proposed in September of 2015 first-time regulations under Quad O little a, methane from numerous sectors or subsectors of the industry. During the same time period, EPA also issued draft control techniques guidelines, which would be for existing sources, for sources in the ozone transport region, and in any non-attainment area for ozone greater than the marginal non-attainment. I had talked with Anthony a little bit before and did a little research. I'm fairly confident that's not going to be an issue for Ohio sources, so I think that's a good news for the industry here in Ohio. But again, this also relates to the October 26th when EPA lowered the standard for ozone. In June of 2016, EPA finalized Quad O little a with a number of changes that made it more stringent. Probably most easiest to look at was the removal of the low production well exemption. the previous speaker was commenting on the age of the wells and producing about 54% of the actual production was coming from these older wells. Now, I don't know exactly if they would qualify as marginal wells, but this low production well exemption would be of great interest and value to the industry in Ohio, and EPA removed that particular provision. We went down, met with EPA, Research Triangle Park, and tried to talk to them to find out what had happened, because in the proposal they seemed to have the information they needed for the production exclusion or the exemption, and EPA simply told us, well, we got one set of comments that said, well, these low wells have as many, or these low production wells have as many components as the larger wells, and it's not a function of production, it's a function of components, and so we pulled the low production well exemption. So more about that later. August 3rd, we pulled together, OOGA included, this time 18 national and state associations challenged the Quad O-A regulation, again in the D.C. Circuit, and we also filed a petition for reconsideration with EPA. October, EPA finalized the control technique guidelines, and November 10th, EPA announced the issuance of the ICRs. Impact of the election. It was kind of funny. I wasn't necessarily a big Trump supporter, but I was sort of in the anyone but Hillary camp. But I also was not in a mood to listen or watch the news that particular night. So I did what I sometimes do, and I apologize. I'm from Pennsylvania, so my team is the Steelers. I know that's probably difficult or not wise to say in this crowd, but sort of like with my Steelers, when they start to lose, I'm one of those bad Steeler fans that get really grumpy, and I just turn the TV off, and my wife's much happier if I don't watch the rest of the game. Same kind of situation. I didn't want to hear the poll, or thinking that the polls were going to be somewhat accurate. I just actually had another gin tonic, went to bed early, and just turned the news off, and I woke up a couple times during the night and resisted looking at my phone. Finally, about 5:30, I looked, and I was like, just raised my arms up, like, holy shit, he did it. And I woke my wife up, and she's like, shush, go back to bed. So anyhow. But it's been very interesting. So this is a little bit of a be careful what you ask for. I think folks are thinking there are going to be great changes, and the first information there is in 2016 there were over 15,000 full-time employees at EPA. Of those 15,000 plus employees, only 13 of them are presidential appointees with Senate approval, and there are about 185, at least in 2016, there are about 185 non-competitive appointment positions. Not all of those obviously have to be Senate approval, but again, those are we've got a very small percentage of folks that Trump can put in to actually influence what's going on. Last week, you may have saw OMB came out with the first proposed budget, and you can see the numbers: 25% cut fiscal year 2018, 30% reduction in state grants, 20% reduction in workforce, and reducing, and just recently, I think this week or last, announcing to try and reduce the number of regional offices from 10 to 8. There are a couple other things that I would add to that that just people need to keep in touch or keep in mind of. In that time period, when waiting for the approval of Pruitt, there was information indicating that on the very first day, Pruitt was going to show up at EPA headquarters and meet staff and talk with them. Apparently, there was a Twitter account that came up that was called Rogue EPA Staff. And a couple of the comments I thought were interesting. Quote, unquote, if they invited staff, open parentheses, unlikely, close parentheses, few would come. And the question was also raised on the Twitter feed as to why would Trump come if not to meet the staff. And basically the response was, quote, photo op for Fox and Breitbart, I don't think so. So, and then adding to that was comments by former Bush era EPA Administrator Todd Whitman that basically indicated that once Pruitt arrived, it was going to be, quote unquote, a bloodbath when Pruitt gets in there. So there's reason to be optimistic, but I think we all need to be aware of the fact that while we would like to see EPA's probably budget reduced and the number of employees reduced, we do still need adequate staff in there, and the new administration is going to need to work with the 14,000 plus staffers and folks that are somewhat career employees. And in fact, it's kind of interesting. I do some work for a nonprofit that works for Chesapeake Bay Restoration. It's a nonprofit that doesn't litigate and doesn't lobby, so I avoid conflicts of interest. But they're a good group. But what's interesting is they've been very concerned. They rely on a lot of EPA grants. And even since OMB came out with their budget, Pruitt has actually been one advocating for retention of the state grants. And his platform has been largely on federalism and letting the states take the lead. Some of my NGO friends are kind of laughing because they're actually having to rely on Pruitt to keep some of their funding. They thought they'd never be saying that. Additional impacts of the election, Congressional Review Act. So far, we've had 2 Senate rescissions in terms of impacting the oil and gas industry with the, well, I shouldn't say yet, 2 that are through the Senate, and I think one still needs to be signed. But basically, the SEC rule with regard to disclosures was pulled back through the Congressional Review Act, and the BLM 2.0 was passed, I think, 2 days ago, and I don't know if it's been signed yet. And we're still working for the BLM venting and flaring rule. We're not sure, from what I hear from folks in Washington with IPAA, not sure that we'll have the votes to get that passed. Additional actions that the President's put in through primarily executive orders include the regulatory freeze pending review, the delay of effective dates for 30 final regulations. There have been other measures since then that are trying to delay regulations or the effective date of regulations on a couple different fronts that are of benefit to the oil and gas industry. On January 30th, we had the EO on reducing regulation and controlling regulatory cost. We have enforcing the regulatory reform agenda, where basically setting up regulatory task force within 60 days and have them report out within 90 days of particular regulations that various agencies can get rid of and do without. On February 28th, we had another EO dealing with Waters of the United States, or WOTUS, and then there was also on that same day a pre-Federal Register notice of the intent to review and rescind or revise the Clean Water Act. That actual notice came out on March 6th, so that's in the Federal Register. And I want to dig into that a little bit more closely, look at a couple of quotes that were actually in the notice, because I think even though it's a water issue, it's, I think, also telling and something that we can hopefully take some comfort in or look to. A couple, I think, very interesting quotes. Agencies have inherent authority to reconsider past decisions and to revise, replace, or repeal a decision to the extent permitted by law and supported by a reasoned explanation. That particular quote is coming out of a Supreme Court decision, so I pulled up the decision, did a little reading on it, and what's I find kind of ironic is it actually has to do with an FCC matter against Fox production. And ironically, it has to do with Paris Hilton and Nicole Richie and Cher making obscene comments during the Billboard Awards in 2002, 2003. And again, the decision was by Scalia, and the FCC, they didn't rescind any regulations or anything of that nature, but they basically were revising and changing on the fly their policy and how they were enforcing it in terms of obscenities and things of that nature. So in addition to the quote that was put in the Federal Register, there was additional quotes that I thought were of interest to this group and for us as we go forward in the Quad A litigation. Agency action is not subject to a heightened or more searching standard of review simply because it represents a change in administrative policy. Another quote, not every agency action represents a change in policy need be justified by reasonable or more substantial than those required to adopt the policy in the first instance. The second quote on the slide here was actually just from the Federal Register notice. It was not anything particularly attributed to or a quote from another case. The third quote is also is actually attributed to a case involving the National Association of Home Builders, and this was at the Court of Appeals for the D.C. Circuit. And it was a 2012 decision, and it was a post-Fox, the FCC Fox decision. The facts here are interesting, very similar to what we have, the situation we have right now. Going back to laying the groundwork, in 2008, the Bush era EPA administrator published a rule regulating activities associated with renovating and remodeling particular homes, and worried about lead paint. But there was an opt-out provision in the regulation that if the owner-operator or the homeowner certified that there was no pregnant women or young children in the home or the facility, they could opt out and they didn't have to comply with all of the various remodeling and revisions associated with lead. So that was 2008. Various parties at that time challenged the rule. In 2009, we have changed administration. Obama comes in and enters into a settlement with, I think probably Enviros. I didn't see the parties that they entered into a settlement, but in that settlement it was specific that they actually agreed that the agency would take steps to basically take out that opt-out option for homeowners. So 2009, changed administration, they entered the settlement. 2010, EPA, the Obama EPA amends the rule to take out other portions. National Associate Home Builders sues for violation of the APA and the Regulatory Flexibility Act. Basically, again, EPA cited Fox for the change position. Is not subject to more scrutiny, and a couple of valuable, I think, quotes. Another valuable quote or two that was not used by the Trump administration deals with EPA need not rely on new facts, but rather on a reevaluation of which policy would be better in light of the facts. Let's see here. There were in fact. In the oral argument, and in the briefs, the Home Builders Association argued that the only change was that the settlement agreement that EPA entered into, and the court said, oh no, that wasn't the only change. There were in fact two other events of note, both of which precede the settlement, that go a long way toward explaining why EPA reconsidered and adopted and considered the opt-out provision. Namely, the inauguration of a new president and the confirmation of a new EPA administrator. So this is the D.C. Circuit Court of Appeals, which we are before right now on the Quad O little a and Quad O and Quad O little a litigation. A couple things of interest, at least from a lawyer standpoint. There's the three-judge panel that made that decision. The first judge that actually wrote the decision is Judge Merrick Garland, so that's a name you might have heard recently. He wrote the decision. Obviously, he was appointed by Obama. Judith Rogers was the second who's a judge on the panel. She was appointed by Bill Clinton, and then, which was interesting also, is that she was appointed to replace Clarence Thomas. And I think if you look at her record and Clarence Thomas's record being appointed by Clinton, it's just kind of interesting how far we've gone down from being able to actually look at the actual credentials and not have politics influence what's going on at the bench, but that's another discussion. But I am rather cynical in terms of looking at even if we got these same judges, I'm sure that they would look at things a little bit more differently. At least, I'm sorry, that's my opinion. I think they were going to look at things more differently. And in fact, when Bush tried to change various policies, when he came in, they had mixed results at the D.C. Circuit Court. It's a difficult place to overcome EPA's and the bias that exists there. Okay, continue impact the election, March 1st, 2017. We have Texas AG taking the lead with 10 other states and requested Pruitt to suspend, withdraw the ICR that I'm sure all of you are familiar with and at this point seems to have wasted a lot of time and money, resources responding to it, but we were successful in our efforts to motivate the states to make a request for the revision or the withdrawal of the ICR, and that promptly came on March 2nd. Some folks are still concerned about the control technique guidelines, particularly if you have operations in Pennsylvania as well. And just like the ICR, it's guidance or guidelines, and it could be easily withdrawn just like the ICR. The difficult part there is it has more regional focus, and not all states are going to be concerned about it. Oops, sorry, how do I go back? Okay. With regard again to the impact more specifically of the election on our existing Quad-O litigation, we were successful. We were supposed to propose a joint briefing schedule to the court shortly after the transition to the new administration. We were able to get by 45 days. The EPA did not object to that and gave us an additional 45 days. That put us out to March 20th. At the time that we got the extension, we actually thought we might actually have people in place in the administration that could make decisions and maybe give us a clue as to where the current administration wants to go with the litigation. I don't think we foresaw the stalling techniques and the delay in getting the various people appointed. So we have the counsel for the industry petitioners and the state petitioners in the Quad-O little a litigation have a call later this week where we're going to discuss potential next steps. I haven't talked with any of the other attorneys, but I guess I'm assuming we're going to probably try and get an additional extension of time. And this is just to put forth a joint briefing schedule. One of the things that I plan to discuss, and some folks have raised an interest in, most of obviously the effective dates of the compliance dates for Quad-O little a have come and gone, but the one that remains is for the LDAR, and that's not an insignificant one, although folks have certainly invested lots of resources in compliance with that. That might be something that we can maybe get a 90-day quick delay on. It wouldn't be a difficult decision for the new administration to give us some time. Two strategies or two paths I foresee for the litigation. One is litigate, which I kind of refer to as damn the torpedoes, and stay or settlement. To understand sort of the strengths and benefits of one proceeding one way or another, I've put together just a short list of the way that we broke up the issues for the Quad-O little a litigation with truly legal issues, judicial review, threshold legal issues that if we win on, the entire rule would probably go away, and as opposed to implementation issues that we could possibly tweak through the administrative petition process. We had this strategy before the election, and what we wanted to do by doing it in this manner, we wanted to get to these threshold legal issues as soon as possible, and if you overlap your judicial review issues with your administrative petition review issues, you can inadvertently shoot yourself in the foot because the EPA will run into court and say, well, you've petitioned for administrative reconsideration. The rule really isn't final yet, so they can drag out the process. Little did we know that the election would turn out the way it has, and one option we have is to file petitions for administrative review of these same legal issues. That would give EPA cover and the administration cover to say, oh, look, they petitioned for reconsideration. The rule really isn't final yet. We don't have to, hear it on the merits. But again, that goes back to what ultimately the parties are going to decide, whether they want to try and actually litigate these issues before the D.C. Circuit or work to make the rule better. In terms of continuing the litigation, certain things, factors to consider. As I mentioned before, the D.C. Circuit is not the most friendly venue to challenge EPA in. Very difficult. I don't know what the statistics are, but it's generally not a friendly place to be trying or challenging EPA rules. Good legal arguments on a variety of those threshold issues that were on the previous slide. But there's no slam dunk in any way, so you're rolling the dice to a certain degree. and depending on what the administration does, this case, it may not even be in our hands as petitioners, as if EPA pulls out or DOJ pulls out. There may not be any case in controversy. We do have interveners, state interveners, and environmental interveners, but they are all in the case as a result and in support of EPA. So unlike some of the other cases where the environmental interveners have come in and challenged other aspects of the rule, where Trump, if the administration wants to pull out, they still basically, I don't want to say standing is not the right word, but they basically have issues that they can continue the litigation independent of EPA. I'm not sure that that's the case in our Quad O litigation. Stay issues, in terms of stay or settlement, greater degree of control and pick and choose what we want to try and fix. It's potentially faster. If you're looking about pulling the entire rule and starting over, you're looking at probably 3 to 4 year process. You're going to have to refute what's in the record already, and if you get it done in 3 or 4 years, you're doing well, and Lord knows where we're going to be in 4 years in terms of the next administration. So this is a potentially faster, quicker way to get revisions to Quad O. One of the bigger issues that we continue to evaluate is one of our biggest problems with the methane deals with the methane regulations is it opens the door to potential regulations of existing sources. The petition for administrative reconsideration, I talked about those briefly. I'm going to jump to through a few slides here to save some time. But these are issues that we are working on with EPA, even though we don't really have any adults at EPA right now to make decisions. The low production well exemption, we're working with an entity to potentially put together a protocol so that we can get that low production well exemption put back in. We have not had any discussions with the EPA on Quad O litigation, so I spent a little time looking at what the courts have been doing or what the administration has been doing in various cases that are active right now. The first case deals with the air toxics rule and Obama rule before the D.C. Circuit, and EPA, the Trump administration, supported the existing regulation, and it dealt with the regulation of toxics and basically regulating, I think, 90% of 7 different toxics. EPA and the Trump administration supported this rule, but when you look at it, there could be reasoning that this is good to keep it in because it's a guard against something becoming more stringent. It basically satisfies the requirement, and it's something that possibly industry could live with. Second case deals with hydrofluorocarbons and the regulation of hydrofluorocarbons under a program basically saying that we can regulate them to reduce the greenhouse gases because they're also greenhouse gases. And there's a question of whether that was an overreach to use the particular program that they did. So another example where the administration has supported the existing regulation, but one might question as to why they've done it. This might actually be a decent test for and get a decent ruling out of the Court of Appeals where, yes, EPA went too far in trying to control the hydrofluorocarbons. Gloucester County School Department of Education pulled the guidance on transgender bathrooms. This was an issue that the administration pulled as soon as they got in. They pulled the guidance that was at issue. The two parties, EPA is not directly involved in the litigation, so and just recently the case was up for cert with the Supreme Court, and they basically kicked it back down to the lower courts. So again, it was just EPA's example of Department of Education pulling guidance under the new administration. This February 27th case has nothing to do with EPA, but perhaps is as telling as what was said in the Federal Register notice for the waters of the United States, and it dealt with a voter ID discrimination case. And this is the first example I think we have of the new administration, DOJ, going in and really 100%, 180-degree about face, and they pulled support, backed out of the case, and said there was no discriminatory intent, which was 180 degrees opposite of what they argued up until the new president. As we talked about, the executive order, very good positive language in there, I think, for the industry going forward. The state of North Dakota is the power plant on the new source performance standards for electric-fired, fossil fuel-fired power plants. And four of the petitioners in that case came in and it sounds like they did what I was talking about in terms of potentially doing with our petition for reconsideration. Four of the petitioners came in and filed petitions for reconsideration a while back. They were denied, and when those petitions for reconsideration are denied, you can appeal that decision. And these four petitioners have sought to join and basically extend out the case by joining their petitions for reconsideration that were denied. And EPA basically filed what I'm referring to as a 7-day punt. They weren't in a position to respond to those motions, but again, it's only 7 days, and it will be interesting to see what EPA says. Again, it will be, I think, telling in terms of where we might see things going with the Quad O litigation, Quad O and Quad O little a. I think that's all I got, and probably out of time. Okay. Well, thank you.